Yes, Mr. Peacock.
Lord, we've broken, when I was looking at Sprite Beam, if you still have
Sprite
it,
Beam.
volume 3,
Yeah.
tab 55. Paragraph 51, the share recipient issue. And I sort of walk you through this rather than me read great chunks of it. Paragraph 54, Mr. Prosser is appearing for the taxpayer. Mr. Prosser's primary argument was that it was not enough that a person received something for tax to be chargeable. And the Upper Tribunal say that argument, as we see it, breaks down into 4 elements, which they identify. Top of the next page, Mr. Ghosh did not dispute those propositions as propositions. The substance of the disagreement between the parties centres on elements 2 and 4. Paragraph 55 makes the point that the question of whether you needed a source was left open in Brown, but they proceed on the basis that you do. And then 56, as to Roman 1.
Sorry, just going back to Brown for a minute. There is, or at least there may be, a difference between something having a source and being able to identify the source. The payment, it's got to have a source. It's got to come from somewhere.
Yes.
You may just not be able to tell exactly where it has come from.
I think the tax case principles work on the basis that in order to be taxable, you do have to identify the source.
In the right year, it was often an important point too, wasn't it? Post-cessation receipts managed to escape taxation.
That's right, my lord. And there was a trick with interest on bank accounts. If you closed the account, then the source was said to have disappeared, even if you opened the account a few days into the next year.
Yeah.
And there are now rules dealing with that, but my lord is right.
Yes.
But Roman 1 in 54, I didn't specifically identify, but it has to have the character of income. And then in 56, they say, we do not believe this was seriously in dispute. The value of the shares was consideration for the use of the money and therefore was income. So the other attribute or factor there was that the shares were received as if interest. It was payment by time for the use of the money. And then as to Roman 2, that it must be the recipient's income. They identify an old case called Watkins. And then in paragraph 58, just to note really, rather than if we need to turn up, there's a reference there to a case called Steedford and Below in the 1930s, which was a case about the retired headmaster of Bradfield College who was granted a purely voluntary pension. And that was said not to be taxable under case 6. And the reason given is that by Viscount Dunedin at the foot of that page, it's a merely voluntary gift. Over the page, paragraph 60, there's discussion of my lord's case about the contribution to make up a hole in your trading receipts for the Falk ice rink.
Oh, yes.
And the answer as between the combatants in Sprite Beam was that, well, that was a payment made and received in the context of the taxpayer's trade. So there was a source in the trade itself. There's then discussion of a case called Drummond and Collins about a discretionary trust where payments were made to the children's mother. And the question was, were they taxable in her hands or were they merely voluntary? And the court comes to the conclusion that the limited right to require the trustees to consider the exercise of the discretion was a sufficient interest in the trust fund to render the payments taxable. That last sentence of 61 is important for a reason I'll come back to. It was the limited right was enough of an interest in the trust fund. So there, the trust fund was the source. And then over the page, paragraph 66, there's discussion of a case called Cunard's trustees, which I want to come back and show you. But just note for now that it's discussed in Sprite Beam in paragraphs 66 and 67. Then the conclusion the Upper Tribunal and Sprite Beam draw is at 68. conclusion we draw from the authorities to which we have referred is that it is immaterial that the recipient cannot enforce payment. What matters is whether there is an obligation on the payer to pay. They use that to divide Steedford from Drummond. And they say towards the tail end of paragraph 68, in the present case, the right to payment may not have been enforceable by the share recipient, but it was not voluntary either. The borrower was under a contractual duty to the lender to allot additional shares to the share recipient. And that was then sufficient to justify the conclusion in paragraph 69 that the source of the income was in effect the loan itself. And that's made clear by their ultimate conclusion in paragraph 82, page 1055. Here, the source of the share recipient's income was the loan agreement. And then their statement of principle at paragraph 84, we think rather Mr. Ghosh is correct to say that the required connection between the taxpayer and source need not be limited to legal rights, but can include the situation where the payment is made pursuant to any legal duty owed by the payer. Reasons I'm going to come to in a moment, we say that puts that proposition slightly too wide. But Sprite Beam is an example of a case in which there was no right in the recipient, but there was an obligation in the payer. Next category of cases is where the courts have found a source in the making of a decision pursuant to the exercise of a discretion. Now, our submission as a matter of principle is that a decision without more is not a relevant source for income tax. The best way of testing that is a decision is made to make a voluntary payment or a gift. Like the voluntary pension in Steedford and below, that was pursuant to a decision, but the decision itself was not enough. Kerrison itself is an example where a decision was made to waive a loan, but the voluntary waiver in pursuant of that decision was not a sufficient source for case 6 purposes, because there was no legal relationship between the waiver of the loan and the rights attaching to the shares in Kerrison. That was the judgment of the Upper Tribunal in Kerrison, in effect adopting what my lady had said at first tier. There was no legal relationship with the underlying property.
But Cunard, there was no obligation to make a payment. There was an obligation to consider.
Yes, and I want to come to Cunard now. I'm progressing, I hope the court sees, along a spectrum towards the facts of this case. So just before we come to Cunard, there are, at least theoretically, possible sources here that can be summarily dealt with, and we say dismissed. It can't be the trade carried on by the partnership. If we're right on PIP, then all of those profits have been taxed. It can't be the special capital itself. The thing received can't be its own source. You have to find something else. It can't be some kind of service of the partners to the partnership. Just pausing there, this was the basis on which the tribunals found a source in the Odie case and in HFFX. So in Odie, in the first tier, it's paragraphs 376 and 379. In HFFX, it's paragraphs 170 and 171. And in the Upper Tribunal in HFX, it's paras 100 and 101. There they find the source in some kind of service provided by the partners to the partnership. And we say, no, the service that those partners have provided, qua partner, go to generate the profits of the partnership, of which the trade is a source, and those profits have all been taxed. So the only candidate remaining is either the LLP deed itself, or, to refine that, the exercise of a power conferred by the deed, here being the power to reallocate special capital. But it has to be somehow different to a decision to make a voluntary payment, which we know from the decision of the House of Lords in Steedford and Bellow isn't enough. So at this point we need to turn to Cunard, which is in the first volume of authorities. Tab 27. Decision of this court in 1945. Property was left in a will trust by the deceased to her sister, or for the benefit of her sister. And in particular, the sister was provided with a property to live in. And the income was to be applied to or for her benefit, the sister's benefit. But if there were insufficient income in a given year to keep her in an appropriate style, the trust conferred a power to apply trust capital so as to make up the missing income. So the question for the court was whether those applications of what otherwise were trust capital so as to supplement the income, were they taxable in the hands of the recipient as income? And that was a case 3 case. So important point to note about Cunard, it's not a case 6 case. And the court concludes that just looking at held on page 246 of the bundle, that under the terms of the will, the purpose for which the payments were made was an income purpose and nothing else. The payments were annual within the meaning of Rule 1 of Case 3, and the payments were properly chargeable to both income tax and surtax. Picking up the court's judgment in the words of Lord Green, it begins at 253 of the bundle. The Crown was the appellant because they'd lost in the High Court, and the Crown succeeds on appeal. And Lord Green's judgment for our purposes begins at page 255. Foot of that page. The payments, therefore, in my opinion, were properly made, and at the moment of payment became income of the recipient, Mr. Peters. They were in their nature entirely different from the payments in question in Corbett's case. Corbett's case was an earlier case about the dealing with the residuary estates that had been reversed in effect by statutes. This McPheeters title to the income arose when the trustees exercised their discretion in her favour and not before. At that moment, a new source of income came into existence. The payments came to Miss McPheeters under the express terms of a will, not by virtue of what I may call the quasi-interest enjoyed by a residuary legatee. pausing there, that's a case 3 decision. Then between the two hole punches on page 256, Mr. King argued that these payments were not taxable because on the true construction of the statutory provisions relating to case 3, they were first not annual payments and secondly discretionary and therefore voluntary payments, which Mr. McPheeters could not claim as of right. Then the court sets out the statutory language of case 3, and they deal with the first argument on the basis that they should be seen as annual, as that's properly understood. And then picking it up at the foot of page 256, the second argument also, in my opinion, fails. It was suggested, however, that the rule does not extend to mere voluntary payments, but the payments here were of a totally different character. They were not voluntary in any relevant sense, but were made in the exercise of a discretion conferred by the will out of a fund provided for the purpose by the trustees. It's true, of course, the trustees had an absolute discretion whether to make a payment or not. The question whether they should do so is one which they were bound to take into consideration. I won't read all of it out, all of it's relevant. And then the next full sentence down, the money when received by Miss McPheeters was received by her through the joint operation of the will and the exercise of their discretion by the trustees.
Why can that line of reasoning not be applied mutatis mutandis to the present case, where the payment is made in exercise of a discretion conferred on the corporate partner out of money which we know from analysis of the scheme as a whole has always been destined to go along these courses before ultimately reaching the hands of the individual partner? Or it just sensibly be seen adopting the purposive construction as a deferred bonus?
As a deferred bonus, my lord, raises the problem that involves this court seeing what is received here as being an additional reward for the services provided as a partner.
Well, I mean, is that a legitimate way of proceeding when, as one has to, one looks at the arrangement as a whole rather than at the compartment, at the stages comprising the composite transaction step by step?
My lord, I'm not suggesting this court can't look at the transactions as a whole.
No, I mean, that's elementary nowadays.
I quite accept that.
And whether one calls this a Ramsey approach or not, it's just a purposive approach, which for nowadays we're told is all Ramsey is anyway.
Well, that's also true, and a point I'll no doubt, or we will no doubt come back to tomorrow. I accept all of that. But the conclusion that your lordship is suggesting involves finding that this is an additional reward for a given year for the services of the partners in that year.
Yes, and the decision having been taken at an early stage not to take the whole of the remuneration as a direct distribution, but rather to take 1/3 of it, normally directly, and the other 2/3 via the PIP.
In circumstances where it is important to recall, those sums were not necessarily going to be received.
No, but it's unlike the will trustees, the trustee, the corporate partner in this case, had no power to make any distribution without a recommendation to do so. And the recommendation was in respect of an individual partner, recognising that partner's contribution to the overall business.
Yes, and there would be a recommendation. That recommendation wasn't always followed.
No.
So the first tier identified instances where that was not so. Even where a recommendation was followed to make a provisional award, not all provisional awards became final awards.
No.
But even accepting all of that and accepting my lord's observation that one must look at the whole of this, which I quite accept, it involves a conclusion that the income here and the source of the income is the services provided by the individuals. As partners in the partnership, in contribution to the partnership's trade, where it is in necessarily common ground between us that all of those profits of that trade in that year have already been taxed.
But that, by direct parallel with the Cunard's case, where it's the combination of the will and the discretionary decision of the trustees, here you have a combination of the partnership deed, which provides the structure, if you like.
The proxy for the will.
You have a recommendation by the partnership board, and you have decisions, well, at both stages, at both the provisional allocation and the final allocation, you have recommendations and decisions. So you have a composite process in effect.
There is a process.
It's a parallel.
There is a parallel, I accept that. But in Cunard, two things were relevant. Firstly, it was a power to apply, I'm not going to beg any questions, but to apply monies to supplement income. And that served to clothe the receipt by the individual of an amount as being a receipt of that which was in nature income. And secondly, in Cunard, what in effect is said to be the source of what is said to be income is the trust fund itself, because it was a power to apply what is otherwise capital of the trust so as to supplement income.
Where do you take that from? It doesn't explain it, I think, quite in those terms, does it?
Foot 256, my lady. Lord Green's sentence, the payments here were of a totally different character. That's his conclusion. They were not voluntary in any relevant sense, but were made in the exercise of a discretion conferred by the will out of a fund provided for the purpose by the testatrix. So he is not there focusing on the mere decision. It's the decision to apply what is otherwise capital of this fund pursuant to the power to supplement the income of the recipient.
You've rightly made the point this was not a D6 case, it was a D3 case. Would it have been necessary to identify a source in the D3 case? It was.
Yes, all income needs a source.
Right.
So can I say that Cunard is irrelevant because it's D3 and not D6? No, I can't say that. I have to accept that one is entitled to look at it. But it's not just a decision, even pursuant to a discretion in Cunard, that matters. It's the fact that there was a discretion pursuant to a document, the will or here are arrangements, by which what is otherwise capital of this fund can be given as income. And one can't divorce the decision in Cunard from the fund out of which this payment was made.
You can't, if you sit here, you can't divorce it from the partnership deed, which is the ultimate source. I mean, it's just partners who enter into the PIP arrangements, either on a voluntary basis early on or on a mandatory basis later. I mean, the common sense of the matter is they're just taking their remuneration in two different ways. One very roundabout and the other very straight.
My lord, even if one describes it in that way, inherent in that, my lord's proposition, is that what they receive is taxable as their income, notwithstanding that all of the income of all of their activities collectively have already been taxed.
You keep coming back to
Yes.
this.
Well,
Yeah, I mean,
but
maybe that's a knockout point, but I mean, it's central to your argument.
It is, but it's ultimately on miscellaneous income, and indeed when we get to sales of occupation income, it's the start and the end of the inquiry. Everything else is important that we should look at it, but one can't get away from the fact that the commissioners, once they've lost on PIP, are trying to solve a problem of the disparity between the corporation tax rate and the income tax rate.
No.
and this court should not be encouraged to develop or amend or read the law in a particular way to aid that effort when there is no problem to be solved.
Yeah.
So Cunard, once one reads it really, really carefully, I say, is not an authority that identifies a proposition against me. And the other way that it was put below that I should just deal with is that it said there must be a Braganza type fetter, is the way it's put, on the exercise of a discretion. And I quite accept for present purposes that the exercise of a discretion here under the PIP programme was a discretion that had to be exercised fairly and in good faith. But the fact that there's a fetter on the discretion does not itself amount to some kind of legal obligation to pay. And even if it did, that is not itself a good enough source for case 6 purposes for the reasons I've advanced. So in accepting this point below, both the first tier and the upper tribunal, we say, have misunderstood the relevant principles and taken from Cunard in particular a proposition that is not justified by Cunard. One other point I should come back to on the scope of 687, we have had printed over the short adjournment the explanatory notes. I'd like to hand those up because it answers a question my Lord Justice Henderson put to me this morning, which
I should perhaps also say that during the short adjournment, the supplementary bundle of authorities has come to light.
found.
It was stuck in the post room.
Well, just so you know what's in there, there's bits of legislation, there's a couple of bits of Lindley and an extract from Whitaker, and there's a couple of bits of revenue manual with illustrator, a couple of small points. My Lord put to me this morning that the language of 687 is ostensibly broader than the language of case 6.
Yes.
And I made the point that case 6 was designed to be the sweep-up provision for all of Schedule D. And what I didn't say and should have done is that, of course, Schedule D was itself designed to be the sweep-up provision for all the other schedules. So Schedule D played a residual role, and then case 6 within Schedule D played a further residual role. So when you come to the current language, it is not an expansion on what was there before. It is an encapsulation of what was there before. And I can make this good just by looking at these paragraphs from the overview rather than from the commentary on 687 itself. So paragraph 2627, the chapter charges to tax any income that's not charged by any other income tax provision anywhere. 2628 says Schedule D is the residual schedule into which income falls for income tax purposes if neither ITEPA nor another schedule of ICTA applies to it. And they set out section 18. Then 4 lines up from the end of paragraph 2628, the tax is charged under Schedule D case 6 in respect of profits or gains not falling within any other case. And 2629, case 6 is itself the residual case under Schedule D. Schedule D case 5 includes an identical function for relevant foreign income. So there was a sweeping up function in case 5. And drawing those threads together, 2630 says, so far as is practical, income charged by the source legislation under Schedule D cases 4 to 6 is the subject of separate charges in this Act. And there are examples. And then paragraph 2631, this chapter brings together the sweep-up functions of cases 4 to 6 and it contains the charge to tax on two types of income, where in most cases income will be wholly covered by relief. And then a point I also made this morning, 2632, the charge under this chapter is restricted to amounts that are income on first principles. So the current language takes the sweep-up function of case 6 and part of the sweep-up function of case 5, but it also reflects the fact that Schedule D itself was a sweep-up for the other schedules.
Thank you.
And so that's why there is no relevant change in the scope identified in the tax law rewrite project.
I think you're also entitled to say that their annual profits or gains under Section 18, as that phrase has been interpreted by case law.
Yes.
Could you just remind me who drafts these explanatory notes? Are these from the tax law rewrite project or from the revenue, or?
They are from the tax law rewrite project, I think.
Yes.
My friend is nodding. I think that's right. They were prepared by the tax law rewrite project at the Inland Revenue. So
I think it included some non-revenue participation.
but they're not a revenue official statement, they are a tax law rewrite.
Yeah.
But they do take the form of explanatory notes.
They do.
In parliamentary terms.
They do.
Yeah.
So you are clearly entitled to look at these.
Yes.
Yes.
And I haven't read it out, but then the description of 687 tells you where it came from, Section 18, but it doesn't, for our part at least, have anything to say that bears on this dispute.
No, thank you very much.
But drawing the threads together on miscellaneous income, it has to be income on first principles. We say it isn't. Its profits have already been charged to tax. If you're going to look for a source, and thus the generis to which this is justem, you have to find some underlying thing, a service or a profit or an activity, or you have to find a contractual right to be paid for such a thing, or you have to find discretion to be exercised over a particular type of property.
Would the individual partners
Over a particular
have
type of property.
have a contractual right to be paid once the discretionary decision has been made? They're all bound by the partnership deed.
Once the reallocation had been
Yes.
made, then the assets stood to their credit.
And they would have an enforceable obligation to require that to be done, presumably.
That must be right, yes. But if what is said against me is that it's the entitlement that is the product of the decision, then the mechanics by which a particular sum of money is realised afterwards would not be material. Got to find this. If it's said to be the decision, then the decision has to be justified as the source in its own right.
Yeah.
So those are my submissions on miscellaneous income. That then allows me to turn to sale of occupation income. And as the court has already identified, this only arises if I'm right about miscellaneous income, because if I'm not, then sales of occupation income provisions don't work. The relevant legislation we ought to turn up is in the first volume of authorities, tab 12. Now, the Income Tax Act 2007 starting with section 773, subsection 1, it imposes a charge to income tax on individuals to whom income is treated as arising either under 778 or 779. So there are two possible charges. 778 is where you get a capital amount other than derivative property or right, and 779 is where you get derivative property or right. I'll come to that in a second. 774 sets out what's meant by occupation. I'll come back to that. 776, income tax is charged on income treated as arising under 778 or 779. 7762, tax is charged under the section on the full amount of income treated as arising in the tax year. And then sub 3, the person liable is the individual to whom the income is treated as arising. And that's all subject to 784 on sales of going concerns. And then 777 is in effect the gateway to 778 and 779, and they apply only if conditions A to C are met. So A is the carrying on of an occupation, wholly or partly in the UK. Condition B is transactions or arrangements made to exploit the individual's earning capacity in the occupation by putting another person in a position to enjoy all or part of the income or receipts or anything derived therefrom. And then sub 5, condition C is that as part of or in connection with or in consequence of the transactions or arrangements, a capital amount is obtained by the individual for the individual or another person. And then subsection 7 over the page, page 58, capital amount is an amount of money or money's worth that's not otherwise chargeable to tax as income. So if I'm taxable under miscellaneous income, it's sub 7 that turns off sales of occupation income.
So here, the conditions are the individual partner carries on an occupation. The arrangements in the partnership deed exploit the individual partner's earning capacity by putting the corporate partner in a position to enjoy the all or part of the income or receipts. And the individual partner receives a capital amount at the time when the special capital is reallocated.
That's the argument against me.
Yeah.
Now, going back to 773 subsection 2, there's a further gateway, which is income is treated as arising under those sections, i.e. 778 and 779, only if transactions are effected or arrangements made to exploit the earning capacity of an individual in an occupation. That's an issue. And B, a main object of the transactions or arrangements is the avoidance or reduction of liability to income tax. Now, there was a fight here below as to whether B was met. Tribunals decided that it was, and we haven't appealed that. But the focus, for my part, is on 773(2)(a). Now, point to note that these rules only apply to individuals. They don't apply to companies or indeed to trustees. The individual concerned has to have an occupation as defined, which gives rise to an earning capacity, and that occupation has to be a carrying on of activities of a kind undertaken in a profession or vocation. And 774 defines occupation so as to make clear that it extends to a case where the individual is carrying on a profession or vocation on his or her own account, so the sole trader, or is an employee or office holder. But even as an office holder or an employee, you still have to find the individual carrying on activities of a kind carried on by a professional or those carrying on a vocation. Now that reference to employee or office holder looks rather odd, because you can understand how a sole trader might exploit his or her earning capacity by putting someone in a position to enjoy that. Why does it extend to an employee or an office holder? And the reason for that is explained in a note that was written at the time these rules were introduced, which was 1969, and that's in volume 4 of the authorities, tab 76.
Which tab is this?
76, my lord.
26.
So these rules were introduced by the Section 31 of the Finance Act 1969, and they were designed to deal typically with actors who set up a company with whom they were contracted, which had rights to revenues derived from their acting services, where the individual actor concerned would then sell the shares in the company to a corporate third party in return for either loan stock or for shares in that third party. And what you have at tab 76 is the current law statutes annotated for 1969. It would have been written at the time by a practitioner. It's not impossible to work out who wrote it. But page 1682, rather than me read it out, can I just invite the court to read under the heading commentary?
Yes.
Sideline passage.
I thought you were going to, you told us this was going to explain why office holders are included, but I don't think it does it?
Well, I think it's implicit in circumstances where what is sold is the company that has the benefit of the actor's services.
Oh, I
And
see.
that could either be pursuant to a contract, so I set up a personal service code that employs me, so I could be an employee, or I might just be a director of personal service code. In 1965, the actress Julie Christie entered into a transaction of this sort, although much, much more complicated. And that transaction was examined by Mr. Justice Templeman, as he then was, in a case called Black Nominee and Nichols. It's in the bundle. She did this in 1965. There was obviously some practice of this being done because marginal rates of income tax were 91.25%. Parliament introduced these rules in 1969, and in 1975, Mr. Justice Templeman said this sort of arrangement doesn't work anyway. So maybe these rules weren't needed, but that's by the by. But the basic structure was you had a personal service company, which you sold to a third party, so I might sell my company to Disney, modern language, and I would either get loan stock that would be paid out as I provided my services as an actor, or I might just get shares in Disney.
Yeah.
And that alternative explains the difference between 778 and 779. Because 778 is looking at circumstances where you get property the value of which is not derived substantially from your own efforts. And 779 is looking at circumstances where you get property, the value of which is substantially derived from your own efforts. So the latter would be the loan stock example, and the former would be where you get shares in Disney. Now, what was then Section 31 of the Finance Act 1969 was reenacted in 1970, and then you can trace it through to the 1988 Act and then through to the 2007 Act, and it is in substantially the same form. One other element you should just appreciate at this stage is that the closure notices here charge these individuals to tax on the basis that they received sums that are taxable under 778. i.e. what they got was an asset that does not derive its value substantially from their activities. Now, there's something odd about that I want to come back to, but
Was it also by reference to the value of the investment assets when transferred?
my friend will no doubt be able to explain why that was done. We
But,
don't.
sorry, how was it computed? Do we know how it was computed?
It was computed by reference to the value of the special capital that they got.
Taking account of investment movements or not? We know.
So in my simplistic example where it's the 72 that's invested, at the time the award becomes final, that might be 71 or 73.
Yes.
Well, if things have gone very well, it will be much higher, or catastrophically, it will be much lower. Now, in practice, we know that the amounts were close to 72. It necessarily varied a bit. Just so you know, the charge here is a 778 charge. So returning to the core elements of the provision, you have to be able to find activities of a kind carried on in a profession or a vocation. Vocation was no part of the argument below. So it was not said below that the relevant individuals were carrying on activities of a kind carried on by those conducting a vocation. The vocation being conventionally viewed as a calling or the way a man passes his life. That's Partridge and Mallanday. Lewison Skeleton, paragraph 88 in this court, faintly suggests that he has a contention that there was a vocation here. But that wasn't addressed below. It's not in any respondent's notice. It's not strictly before this court. It's not a tenable proposition. And at this stage, I'll say no more about it. So one can put aside vocation. So one then turns to profession. Did these individuals carry on activities of a kind carried on by a professional? The first tier said that was a question of fact in light of the authorities, and that on the facts, these individuals were doing so, and the Upper Tribunal agreed. Now, we accept that once the term professional and profession is properly understood in the context of this legislation, the question of whether X carries on the activities of a profession is a question of fact. But we say the first tier erred in law, an error repeated in the Upper Tribunal, in its determination of the meaning here of the term profession, reading that term in context. And what the first tier did was to answer the question by reference to the view of the man or the woman on the bus to Clapham, or the DLR to Canary Wharf. That's paragraph 454 in the first tier. We say that you can't answer that question in the abstract without context, and once the context is properly understood, that answer is not permissible.
The answer is not.
Permissible. So what Parliament was seeking to do in 1969 was to make specific provision for those who had an earning capacity as a professional or a vocational, who were able to arrange their affairs so as to put some other person in the position of receiving the fruits of that earning capacity. The rules that were introduced in 1969 were limited to those who had professional or vocational activities. They did not extend to those who carried on a trade. So in old language, the rules applied or not, depending on whether you fell within Schedule D Case 1 or Schedule D Case 2. And it's long been recognised and accepted, we believe, even in this appeal, that an activity could be a trade or it could be a profession, but it can't be both. If one wants authority for that, there's an old case called Maxi, which is in the first volume of authorities at tab 18. Now here, putting aside the partnership form for a moment, the individuals concerned carried on a trade of asset management by which they managed investment funds and either made a profit or didn't for the fund investors. But that activity is a trade for tax purposes and has been taxed as such. And we know that Section 31 of the Finance Act 1969, and indeed the current legislation, are aimed at people who have activities of a profession or a vocation. And we say the purpose of the rules was to prevent people turning what is otherwise professional or vocational income into capital form by ensuring that some third party would receive that income on the condition that a capital amount will be provided to the person with the profession or the vocation.
Do you say, or maybe you don't need to say, that the reason Parliament directed this legislation only at, you say, Schedule D Case 2 situations was what? Simply because that's where the perceived mischief was going on?
Correct.
Because in theory you could do the same with your plumbing activity.
My lady, in theory, the rules could have applied to traders because the Parliament could have said, well, there's a perceived problem with high-earning traders employing clever lawyers to produce a structure that has this effect. But Parliament deliberately, consciously draws a distinction between trade and professional vocation because, no doubt at the time, the cases it was concerned about involved, as the explanatory note says, actors and directors and people of that ilk. But it didn't extend to traders. But we say read in context where you see that reference to activities of a profession or a vocation and the earning capacity of those activities, one has to find someone who has an earning capacity as a professional who is somehow diverting the fruits of that earning capacity to somebody else.
Is there a difference between a profession and a vocation? And if so, what is it?
The law says there is a difference between those two.
What is a vocation as opposed to a profession?
The early cases would say that a lawyer was a professional, I think a doctor was a professional, but a vicar had a vocation. It was Partridge and Mallandane.
Durham says a bookmaker has a vocation.
Graham and Green, it does. Whether that looks right to modernise is a different question.
But we're not necessarily concerned. I mean, if we're looking at the scope of Section 774, we've got a composite phrase here.
Correct.
So whatever vocation means, it may throw some light on the intended scope of 774. And if it were to extend to bookmakers, that might colour the view that a court takes of where the net is intended to be spread.
My Lord, let me accept that for a moment, and I'll come to Graham and Green in a second. But the divide still, whatever one thinks is the footprint of profession or vocation as a composite whole, it is still ultimately to be separate from a trade.
Right.
And here, these individuals were treated for tax purposes as carrying on a trade. That's how they were taxed. So what the Commissioner's case here has to be...
Where does that come from? I mean, they were a partnership, but if they had been carrying on a profession, they'd have been taxed in the same way, wouldn't they?
Not necessarily, no.
Necessarily.
The rules are different.
Right.
In many respects, the UK tax code aligns the treatment of professionals and vocationals on one hand and trades on the other, but that's not universally true.
Right.
There are still two different parts of the code. But here they were being taxed as traders. So the Commissioner's case has to be, and this is the case that in effect is accepted below, you individuals are carrying on a trade, you're taxable as traders, but because what you do looks a bit like what professionals do, we can charge you to tax on the capital sums you receive because you have diverted what would otherwise have been your trading receipts. And that's not a proposition that can be grounded in the statutory language of what was Section 31 of the Finance Act 1969.
Your context point, as I understand it, is very much, this is in the context of separate charging provisions in what was then Schedule D Case 1 and Case 2.
Yes. And still, even today, my lady, there are differences in the current tax code between those who are treated as carrying on a profession and those who are treated as carrying on a trade. There are not many of them now. There are some.
And there is no dispute that this, in old money, this trade was a trade taxable under Schedule D Case 1.
It's a trade, yeah. So what the commissioners have to do to solve this problem that I say doesn't exist is treat what is otherwise a trading receipt as being a diverted professional receipt in order to justify the conclusion that the capital sum is taxable. And that's not what these rules were designed to achieve. So there is something fundamentally wrong, we say, with the commissioner's position.
How far is it right to, I mean, I think to follow your argument, one really has to do the statutory archaeology of going back to the original enactment in 1969, and indeed it's only when you've done that the legislation begins to look, at least it's much easier to understand what it might have originally been intended to drive at. But I mean, here we have it in what, half a century later, in a context where there's no sign that you have to carry out that sort of an exercise, and it's contrary to what nowadays are pretty much first principles, that one shouldn't go behind consolidation acts or, for that matter, tax law rewrite statutes. And there's some strong reason for doing so.
My Lord, your Lordship's caveat is important. The current state of the authority, if I paraphrase slightly, is that you shouldn't go back.
Yes.
But there may be occasions when it's sensible.
Where it's necessary. And you say this is such an occasion.
Correct.
That's, I see.
Because the 2007 version that we have before us is a rewrite of what was in the 1988 Act.
Yes.
And that you can trace back to source, 1969.
Yeah.
But in order to understand why 778 and 779 are the way they are, you need to see what the original mischief was. And in order to understand why you've got that rather odd suggestion that you can carry on the activities of a professional or a vocational as an employee, you need to go back to 1969. And once you've done that and seen the explanation that was provided in 1969, all of that serves to emphasize that the target was not traders. Now, two points to make in consequence of that. First volume of authorities, tab 17. There's a case called Christopher Barker and Sons against the Commissioners of Inland Revenue. It's 1919 in the High Court. This is an excess profits duty case. So there was wartime excess profits for those who made money out of wartime activities. And it applied differently depending on whether you were carrying on a trade or a profession. And the appellants in this particular case were stockbrokers who bought and sold stocks. So they looked like traders, they were buying and selling, but they were necessarily also providing a degree of advice to customers. And so the question then was, well, is that a trade or is it a profession? If it were a profession, there was a liability to excess profits duty. And it came before Mr. Justice Rowlatt, and his judgment begins at page 85 of the bundle. The first couple of pages, he sets out really the context of excess profits duty and makes the point that it doesn't extend to professionals. And then it's the middle of page 87. Now, is a stockbroker's business a profession within the meaning of this section? And his conclusion is that buying and selling stock is just a trade. It's not a profession within the meaning of the excess profits duty regime. So that's an example of a taxpayer doing something not dissimilar to what BlueCrest do, although no doubt it's much more complicated these days, and being held to carry on a trade in your profession. And then if we turn on, just to deal with my Lord's point, to tab 22, case of Graham and Green. Mr. Graham was not himself a bookmaker. So
No, he was a punter.
he was a punter. So the question was, where he made winnings, were the winnings from a vocation? Well, no.
Hardly surprising, since most gamblers lose.
Well, there's a very strong policy reason for not taxing winnings. That's why would you tax 10 when you've got to give losses of 100 or something?
Although in common parlance, one probably does talk of a professional gambler.
One does, or a professional poker player.
Or exactly, and indeed there may be often a lot of expertise involved in how, without straying across the boundaries of the law, they manage to end up winning most of the time.
Well, yes, and there are some very successful professional punters, but they're not taxable on their winnings because it's not itself a trade. But Graham and Green, the debate was about the ambit of case 6, and again it was Mr. Justice Rowlatt. So beginning at page 165 of the bundle, first whole bunch looking first at case 6, he debates what is a profit or a gain, and then page 167, the relevant part for our purposes, he says, now we come to betting pure and simple, right at the foot of that page. It has been settled that a bookmaker carries on a taxable vocation. So the bookmaker may carry on a vocation. It's rather odd in light of Partridge and Mallandane, which talks about a calling or a way that you pass your life. But be that as it may, there is authority that the bookmaker carries on a vocation.
Yeah.
But that doesn't tell us anything relevant here, because the divide I'm keen on exploring is between professional vocation on the one hand and trade on the other. And we are undoubtedly carrying on a trade. So what the tribunals below did was to say, well, looking at what these particular individuals do day to day, they have the skills and attributes of a quotes professional, in that what they do can be done by people who are undoubtedly professionals. But on the back of that observation, the tribunals below in effect say, well, that is sufficient for this statutory regime, ignoring the fact that you only face a charge to tax on a capital amount where you are exploiting your earning capacity as a professional. And there is no basis here on which to rest the assertion that these individual persons who are carrying on a trade were exploiting the earning capacity of a professional. So the first tier deal with this between paragraphs 429 and 455, but they do not get to grips with the proper context here as to what is meant by an occupation for the purposes of section 774. What the upper tribunals say is, this is their paragraph 133, well, there's no misdirection in law by the first tier as to the meaning of professions. And we say, no, that's itself an error of law, because the first tier and the upper tier have misconstrued the statutory provisions and found an earning capacity of a profession when such is not present. And I should just turn these up. So it's in the first core volume, or volume 1. First here begins its analysis at paragraph 429. So it's miscellaneous, yes, paragraph 49, page 207 of the bundle. And question 2, at the foot of 207, is, we say, is the right question. Were the transacted effective arrangements made to exploit the earning capacity of that individual in an occupation? Right question. 429, they set out the legislation over a couple of pages. 430, the first issue, is the 7732B issue, which is about the main object of tax avoidance. So they answer that at paragraph 438. 439, the judge says, I now turn to the second issue, whether the appellant concerned was carrying on an occupation within 774, in particular whether the activities of that individual concerned were of a kind undertaken in a professional vocation. Well, that's part of issue 2, but it's not all of it. So what you've got to ask is whether the individuals here are exploiting the earning capacity of a professional vocation. And then 440, in fact, 439 all the way through to 451, there's a whole series of cases about the meaning of profession.
And then we get to 451.
And then we get to 451. And that's it's a case about Asher and the film director. And then 452, it's a question of fact. Well, yes, but it still has to be answered in the right context. And then 453, Mr. Gammy had made some points about Pride and Prejudice and Jane Austen. They don't seem to have landed. And then the answer given is at 454 that you ask the man or woman on the proverbial Clapham omnibus or the DLR going past Canary Wharf. But there is no proper analysis in the first tier's decision of the statutory provisions, nor of how they should apply to someone who is carrying on a trade. The Upper Tribunal, behind tab 2, same volume, begins at page 266, paragraph 130. It summarises in short form the statutory conditions. Note at 131, these provisions are anti-avoidance measures designed to prevent individuals avoiding income tax by selling their earning potential in exchange for capital payments. That's true, but not if you're a trader. So they've got the starting point of this wrong. And then in 132, they go back to Brutus and Cousins, profession is an ordinary English word. 133, it's a question of fact. 3 lines up from the end of 133, no suggestion the FTT misdirected itself in this way.
Are you saying that the Upper Tribunal got that wrong? And there was a suggestion that the FTT misdirected itself?
Yes.
That was a point that was argued, was it, in front of the Upper Tribunal? Because the Upper Tribunal seemed to think that there wasn't an issue.
You'll appreciate I wasn't there.
I follow that, yes.
My understanding is Mr. Gammy repeated in the Upper Tribunal the submissions he'd made in the first tier.
Which is what, however you define profession, it doesn't include trade.
Yes. Yes, his Jane Austen divide. But that's all they say about condition A. And then just to save me coming back, I want to tackle condition B separately, but they deal with condition B in paragraphs 134 to 135.
Yeah.
And they reject that argument. And the argument that was that they understood Mr. Gammy to be making was that, well, these were collective efforts, not individual efforts. And my learned friend said, well, it's the collection of their individual efforts, and that's not a good reason not to apply condition B. I want to come back to that. So they reject condition B. They make the point in 136 that these rules can apply to partners in partnerships. And that's right. I want to show you why it's right. And then they reject the argument on condition C. But note paragraph 138, Mr. Gammy submitted that condition C was not satisfied because the corporate partner's profit allocation was included in the partnership's calculation of income for the purposes of income tax and did not represent a capital amount for these purposes. We reject that argument for the reasons which we have given in relation to the miscellaneous income issue. The PIP awards made to the IP appellants were not included in the corporate partner's profit allocation or calculation of income for income tax purposes, because the source of the income was not the underlying trade of the partnership, but the discretionary awards made by the corporate partner. I'd say that's just wrong. Once it is accepted that we're right on the PIP appeal, all of these profits have been taxed. There is no separate second source. Now, coming back to condition B, there has to be the exploitation of the individual's earning capacity from the activities of a professional or a vocational. To reiterate, the Commissioner's case is that these individuals carried on activities of a kind undertaken by a professional. They entered into transactions to exploit their earning capacity. They put another person, the corporate partner, in a position to enjoy such income or receipts, those receipts being derived from the individual's activities, and then an amount not otherwise chargeable to income tax is received by the individuals. The commissioners also say what the individuals receive as a capital amount does not derive substantially all of its value from the individual's activities, hence the charge under 778 and not 779. But that thesis is in effect that what is really a profit share of the individual partner, which reflects his or her efforts for the trading partnership, and to which they would otherwise be entitled, because that has been diverted to the corporate partner, turned into special capital and then received by the individual, that should be taxable in his or her hands, notwithstanding that the activities in respect of which this charge is said to arise are all activities that contribute to the partnership's trade. And we say non-rhetorically, well, how can that be? The individual partners are really getting, in the form of special capital, the individual reward for their services, but that individual reward for their services has to be as traders. So there's a disconnect between the activities they actually carry on and how they're taxed, and then what is said to be the nature of those activities to justify these provisions.
Can I also ask you to comment a bit more, and maybe you will, on the choice of 778?
Yes.
Because I have to confess I'm finding this a little difficult to get my head around, but if the starting point is the argument that the earning capacity is being exploited effectively to divert income elsewhere, it might be thought more naturally to follow that, to say that the income that's being diverted does reflect the individual's activities. Am I missing?
There's a point one on in my notes, but let me tackle it now. There is an oddity about this, because the thesis in effect is you have this earning capacity. That earning capacity has generated what is otherwise 100. You have diverted that 100 to someone else who's provided you with economic value post-tax. But what you get is then not said to derive its value from your activities.
We have closure notices, by the way. I assume it is clear that the charging provision is said to be.
We do, and it does, yeah.
Thank you.
I can give you the references.
I know they're in the bundle.
Core Volume 2, tab 15. Each of the covering letters that went to all of the partners said you're taxable under 778. Now, I quite accept my own friend could lean back and say, all right, we got the section wrong, it should have been 779. But it is indicative of what I say is an inappropriate attempt to shoehorn the present fact pattern into a set of provisions that were just not designed to deal with these sorts of transactions. And my lady may have got this already, but the significance of the difference between 778 and 779 is you're taxable at different points in time.
Yeah.
So one is in effect taxable on receipt, the other is taxable on enjoyment, i.e. realisation. And the year in which you receive special capital is not necessarily the year in which you realise the value from the special capital.
Yes, so as touched on earlier, in this case, the charge, the assessment's charged, or the closure notice is charged at the point of reallocation of the special capital.
Yes. And then if one just looks at the language of 778, is it property which derives substantially the whole of its value from the individual's activities? Now, of course, there's a debate about substantially the whole, I accept that. What my friend is trying to do is to say these provisions apply because you can do some kind of tracing exercise. You can trace what otherwise would have been the receipts of these individuals, brackets trading, into the hands of the corporate partner and then into the hands of the individual. But in order to justify that, you've got to get through the gateway of it being the earning capacity of a professional. And then to justify a conclusion under 778, you've got to say that what comes out doesn't derive substantially the whole of its value from those activities. Now, one further point that the Upper Tribunal identified that these rules can apply to partnerships, and that's true in two respects. So again, one needs to have the legislation. It's volume 1 of the authorities, tab 12. The first way in which it deals with partnerships is to recognise that the person to whom the benefit of the individual's earning capacity is conferred or transferred could itself be a partnership. So section 782 makes clear that the other person could be a partnership. And that's 782 sub 2 at the foot of page 59. The Upper Tribunal used that as a reason to justify the application of these rules to this trading partnership. And those two are different. So 782 is only looking at the possibility that the other person can be a partnership, and it can.
In this context, the corporate partner is the other person.
Yes. Well, it is a company which is itself a partner.
No, but sorry, on the entity who, in this context, the so-called other person is the corporate partner, and what you're saying is the legislation permits that other person
To be a partnership. So let's imagine we're in a world where you've got a partnership that's a member of another partnership. Going back to a debate we had in July, these rules would encompass a world in which your recipient was a partnership itself, or partners in a partnership. So I accept that. But then section 780...
Does it also mean that if you've got a partnership of A, B and C, and A, so to speak, sells his earning capacity to C for a capital sum, that C is also to be regarded as a person different from A?
If you look at
A partnership or partners may be regarded as a person distinct from the individuals who at the time being partners. Does that encompass that sort of situation?
It is, well, if one reads on, it's distinct from the individuals or other persons who are for the time being partners. So that does seem to contemplate where you've put another partner in a partnership in a position to receive.
So C, the other person, is covered here, distinct from A, but C could also itself be a partnership.
Yes. But relevantly here, there is another aspect in which these rules deal with partnerships, and that's in 780 itself. 780 subsection 1 tells you to take account of any method, however indirect, by which property or right is transferred or transmitted, or the value of property is enhanced or diminished. And then subsection 2 tells you what occasions can be an occasion when tax is charged. And then subsection 3 says subsections 1 and 2 apply in particular. And then B, to any method by which any property or right, or the control of any property or right is transferred or transmitted by assigning, then Roman 2, rights in a partnership. So if you do this conferring on the other person by means of shares, of course, if you do it by an interest in settled property, ultimately was Miss Christie's structure. But as regards partnership, you've got to find a transferring or a transmitting of rights in a partnership. And we can tell that that's what it means. If you look at 784, there's an exemption if you have a sale of a business as a going concern. So in those circumstances, these rules are turned off. They're turned off if you obtain a capital amount from the disposal, 1B, of a share in a partnership, which is carrying on a profession or vocation, not carrying on a trade. So it's a transfer of a right in a partnership, special rule for sales of going concerns, disposal of a share in a partnership, but not a trading partnership. So transferring a partnership share, say X confers on Y her 10% in the partnership, and transferring rights in a partnership, X confers on Y 5% out of her 10% right to the income of a partnership, are both within the ambit of the legislation. But the legislation bites on the transfer of partnership shares or rights, i.e. a vested entitlement of the transferor, where the alleged transferor did not have such rights, or at least did not confer such rights on another, the legislation has no application in the case of partnerships. Putting the same point, I hope more pithily, in the context of partnerships, there's a sale of occupation income, but only where there's a transfer of rights. And here, these individual partners had no right to the amounts allocated to the corporate partner. In a world where we have won the PIP appeal, the income allocated to the corporate partner is the income of the corporate partner.
Is what?
The income of the corporate partner. It's not the income of the individuals. It's not income or a share of income or a share of a partnership or an interest in a partnership to which these individuals had a right. So 780 and 784 are important for three interrelated reasons. That reference to a partnership carrying on a profession or a vocation rams home that this doesn't extend to trading partnerships. Secondly, it makes clear that you can fall foul of these rules in relation to a share or an interest in a partnership, but only where what you transfer is that share or that right. And thirdly, in the circumstances of this case, there is, consistent with the court's presumed decision on the PIP appeal, no income or income rights of the individuals that have been transferred or transmitted to the other person.
I think again I've missed something out. Clearly there is some right on your the reallocation of special capital involves some sort of, you would say, transfer of rights in the partnership. And you say that's not what this is getting at.
It has to be, these rules, what constitutes the transfer or the transmission to the other person in a partnership context has to be the transfer of rights in a partnership. So the lady is quite right to say that what the individuals get once the allocation of special capital becomes final is an interest in the partnership. But what they have, it is alleged they've conferred on the other person in a partnership context.
Why do they get an interest in the partnership? They get an interest in, or they may get an interest in investments.
Well,
I don't think there's any obligation, is there, on the corporate partner to invest in investments? Can do if it wants to, do keep the money in cash, presumably.
I think it's expressed in the partnership deed that there is an obligation.
There is an obligation.
We can check that, but I think
I thought it
that's
was
right.
just a power. Maybe it's an obligation. But even if it is, we come back to that discussion we were having this morning about the assets being held entirely beneficially for the subscribing partner. So is it right to say that if the capital is reallocated, the recipient is getting, quote, a share in the partnership?
Well, my case in answer to your lordship this morning was that what you get when the special capital is reallocated to you and credited to your account is, I say, a share of capital, partnership capital, or if not, a share of partnership assets, or if not, a share of assets. Doesn't matter for my purposes of my argument this morning. But what these rules are aimed at is encapsulating the circumstances in which there will be a relevant transfer to the third person, not by the third person. And in order for there to be a transfer to a third person in a partnership context, these rules make clear, we say, that you've got to have a transfer of a right in a partnership or a share in a partnership. And consistent with the world in which the court is with me on the PIP appeal, the individuals are not conferring their rights on a third person. So we quite accept these rules can apply to partnerships, but they apply in the sense that the third person can be a partnership. That doesn't matter for the purposes of this argument. They apply to the nature of the transfer made to the third person. In the context of a partnership, they can't apply here because these individuals have no specific rights to specific income that they confer on it. So that's another reason why condition B is not met here.
So if I'm a partner in a professional partnership and I say to X, for £500,000 I will pay on to you all the profits that are allocated to me for the next 10 years or whatever it is, that doesn't fall within this section?
There's a case called Hadley decision of the
That's the
Privy Council.
New Zealand case, is
New
it?
Zealand case, that said that agreement doesn't alter the taxing incidence, at least in New Zealand.
Right.
May or may not do in the UK. But those circumstances, in those circumstances, either your lordship is taxable in any event, notwithstanding the private agreement, or if what you manage legally to confer on the third party is an interest in the partnership, these rules apply. But if there's no right or interest that you hold that you can confer on the third party in a partnership context, these rules don't apply. So again, there are all sorts of inconsistencies with the Crown's position, but there's the difficulty about 778 and 779. There's the difficulty about this being a trading activity, but then said to be a professional activity. And there is the difficulty about trying to shoehorn in the alleged conferring of a right to income that is taxable in the hands of the recipient as being itself the transfer of a right or interest, which it isn't. So this is again an example, I mentioned in opening, that the commissioners are trying to bang a square peg into a round hole. Now, this condition B was not addressed by the first tier at all. So it's not in paragraphs 429 to 455. The Upper Tribunal inferred that the first tier had addressed it. It's the Upper Tribunal at paragraph 104. But there's simply no basis for that inference. And the Upper Tribunal then simply assumed that condition B could apply here to an interest in a partnership because they say a partnership could be the other person. And here one needs to take up the Upper Tribunal again. Tab 2 in the first core volume, and it's paragraph 136. They say 136, page 268, furthermore, we see nothing in the wording of the legislation to preclude its application because the activities of the IP Appellants are carried on in partnership with each other and with others. That's their conclusion. Section 782 provides that all partners in a partnership may be regarded as a person or persons distinct from the individuals or other persons who are for the time being partners. Well, that's true. That's the identification of the third person, the other person. Doesn't actually answer condition B. They then say the legislation was drafted very widely and was intended to extend to any arrangements made to exploit an individual's earning capacity, I interpolate, as a professional, where the main object, one of the objects, was to avoid or reduce liability to income tax. Well, that's true. For example, if the other person referred to in condition B is another partner or partners in the partnership, there is no reason in our judgment why collective earnings from a partnership would not be called by the section, and that doesn't follow at all. Their reasoning there from the fact that a partnership can be the other person to a conclusion that these rules apply to the transfer of an interest or right in a partnership without examining the scope of section 780. Had they examined the scope of section 780, they should have concluded that these rules cannot apply here, consistent with a world in which we have succeeded on the PIP appeal. So that, we say, paragraph 136 is an error of law.
So do you say that in the context of a professional partnership, a transfer of an interest in that partnership to another professional can't engage legally?
No, it can, if it's an interest in the partnership.
Because that is what you get a capital amount in exchange for that. You confer the right to enjoy income, but you say that has never happened here.
I say it has not happened here. So, my lady thinks back, a large professional firm of solicitors in the City of London where the senior partner decides he or she will confer a partnership interest on some up-and-coming partners. These rules have to be examined. In that circumstance, there may be no tax angle to it, and the main object test is not satisfied. But that is a transaction that could fall within these rules because it's a transfer of a share or an interest in the partnership. Just so that this court sees how this point has also been dealt with below, can we look in the fourth volume of authorities at OD and HFFX? So OD is at tab 65. Very long decision, but sales of occupation income begins on page 1366 of the bundle, paragraph 382.
Now, before we get into this in any detail, are you going to say this is right or wrong?
I need to make observations about both OD and HFFX, and I say right in one case and wrong in the other.
Right.
So just so you see, law is at paragraph 384, submissions, top of page 1367, and they go on for quite a few pages. And then conclusions, page 1372, paragraph 400. I deal with condition B first, as in my view that condition is not satisfied, so I do not need to deal with the other conditions. And in particular, the key reason is given in subparagraph 3. For the reasons set out in part B, my view is that the individual members had no rights in the sense of a legal entitlement to the individual shares awarded to them in the year of allocation. And then over the page, subparagraph 4, it follows that when the individual shares were allocated to PSCL, PSCL was not put in the position to enjoy all or part of the income or receipts of the members derived from their activities of a kind undertaken in a professional vocation, if they may be classified as such. Rather, PCSL received its own income in the form of its own share of the profits of OD. I say that's right. And indeed, on condition B, right for the right reasons. In HFFX, behind tab 67, is the first tier. Tab 66, first tier begins at page 1458. But the relevant bit begins headed discussion, paragraph 209, page 1464. And there the judge just looked at the question of whether these were activities of a kind undertaken in profession or vocation and concluded that they were, paragraph 215, without reflecting sufficiently on the context of 774 and whether this was a trading partnership. So I say that was a mistake, it's wrong in law, and condition B was not argued in the first tier in HFFX. And we know that from the Upper Tribunal report, which is at tab 69. And here it's paragraphs 102 onwards, page 1578. At the foot of that page, paragraph 105, by letter, between letters H and J, the appellant sought to raise as a new point of law, which was not argued before the FTT, that this condition, i.e. condition B.
Sorry, where are you?
Paragraph 105, page 15.
105.
105.
Starting it was common ground that.
Yes.
Yeah.
So common ground that condition C was met, and then
Oh, I
letter
see.
H
Yeah.
in relation to condition B, and then the appellant sought to raise a new point of law. This was on the basis that when GSAM was allocated a share of profits, this represented its own income, not that of the individuals. So what the Taxpayers Council was saying then, Mr. Prosser, was that there's a condition B point. It hadn't been raised below. And the tribunal say, in reliance on the Upper Tribunal's decision in this case, well, that's already been considered by the Upper Tribunal. We're not going to depart from that. And so the parties agreed that they wouldn't press the Upper Tribunal to decide. So condition B wasn't addressed in the first tier, and it's not addressed in any meaningful sense in the Upper Tribunal. So the only decision on condition B itself that bears on this type of structure is in OD, where the first tier decided, paragraphs 401 and 402, that the condition was not met. My understanding is that there was no appeal in the OD case. So for those reasons, we say that if we're right on the PIP appeal, and we're right that there's no miscellaneous income here, and the commissioners can't shoehorn us in to provisions that were never designed to apply to these sorts of transactions through the sales of occupation income gateway, because the structure here is just not one at which these rules were raised. And accordingly, there would then be no sales of income charge on the individual. Now, those are my submissions on that aspect of the case. The original timetable envisaged then that my learned friend would open on, I think he's going to open on PIP and Ramsey.
Right.
And those are my submissions in open.
Thank you very much. So that's right, is it, Mr. Baldry? You're starting off with your Ramsey point.
Well, yes.
Supposed to call it that, maybe.
Yes, we've heard much about the alternative arguments. And really, I'm starting with the revenues appeal on section 850, as we see it. The arguments are in three alternatives for the revenues. The first argument is whether the awards of the special capital are properly taxable in the hands of the partners under the partnership code. If that's wrong, we then go to the residual charge under section 687, and then if neither of those income tax charges apply, we go to the final long stop provision of taxing capital sum. So that was the order that I was proposing to take it. And so in the time available, I'm happy to make a start and sort of introduce what the revenue are going to say on section 850, because both logically, that is the first place to start, and as you may have noticed from the FTT's decision and the Upper Tribunal's decision, in a sense, the reasoning on section 687 follows from the conclusion on section 850.
Yeah.
Looking at what rights have been conferred under the original under the original agreement, and what rights were conferred when the special capital was finally awarded. So, in looking at section 850, what we say is that we have to construe the profit sharing arrangements of this partnership, and section 850 defines the profit sharing arrangements as the rights of the partners to share in the profits. And so what we say we need to do in the present case is examine what were the rights to share in the profits of the partnership. How did the partners share in the profits that the partnership had made? And how did they share in those profits before the PIP was introduced? And what difference did the introduction of the PIP make? We say is essentially, if you look at it broadly, not essentially a Ramsey case, but just applying the ordinary principles of construction and looking at the arrangement in the round realistically, we say that the way that the partners chose to share the profits included not simply the precise terms of the partnership agreement, but the PIP arrangement at which the terms of the partnership agreement were altered to enable. And before going to the details of the partnership agreement, I'd like you to have in mind that an important part of what profits were being allocated to the individuals concerned the discretionary allocations that were derived from the performance fees made by the partnership. BlueCrest carried on the investment management business, and a significant part of the profits of the business were derived from performance fees, which were earned by the annual performance of the funds under the management. And under the contracts they had, the funds crystallised, and therefore the profits were earned on the 31st of December each year. And then under the terms of the partnership deed, those performance fees could be allocated to the individual partners or any partner on a discretionary basis. And before the arrangements which gave rise to the present dispute, the performance fees were allocated to the individuals based on their contribution to the performance fees. So there was a direct allocation of those discretionary performance-based awards to the individuals, and the partners shared in the profits by those allocations being credited to their distribution account. So the profits could be taken out by the individual partners. But the PIP entailed the discretionary performance awards being divided. The way that it worked, as the evidence shows from the FTT, was that shortly after the funds crystallised at the 31st of December, the individuals' awards were calculated based on, if you're a discretionary trader, quite an exact profit and loss account could be made based on the performance fees that the firm had earned as to how much each discretionary trader had made of those performance fees, and for the systematic traders, it was a slightly more discretionary basis. But the starting point in the annual cycle was to work out what was the total award for each of the individual partners. And before the PIP, they could take drawings of that, and then ultimately that award was allocated to them and put into their distribution. But following the PIP, the award was still calculated early in the year. After that, the individuals either had a choice in the early years, or it was settled down as to being a split of 1/3, 2/3, as to which amounts of that total award they received immediately and which went through the PIP. And going through the PIP, it was allocated to the corporate partner. The corporate partner, with that allocation at the year end, used the amounts allocated to contribute as special capital. But a new account had been created, the special capital account, which enabled the special capital to be reallocated to the individuals. And it was the reallocation of the special capital in the special capital account that gave the individuals the balance of their total award, which at that stage they could take out. So instead of there being a direct allocation of the award, there was a direct allocation of part of the award and an indirect allocation of the remainder of the award. And we say that the machinery which that entailed did not reduce the individual's profit share. The partner savings plan, as it was first called when it was introduced, was intended to enable part of the individual's discretionary awards to be invested by the individual, and then they would receive it on deferred terms in such a way that would only benefit from the corporate rate of tax. My learned friend said, well, what's the problem with that? There's no difficulty, it all gets charged a tax. But it does represent a very significant alteration to the way partnerships are and have generally been taxed, because it essentially puts the amount of income tax that's payable by partners with individuals on a voluntary basis, because amounts that are destined to go to the individuals can be allocated to a corporate partner and then reallocated to an individual partner. So it was 2/3 in this case, but it could have been any amount. And it's not, these schemes have arisen, a little clutch of them in a particular sector of the economy, but it's not confined to investment management funds. Anyone could be doing this. So when my own friend says, well, it's been solved now by legislation, and that we now have specific rules to deal with that, we say, well, yes, that is hardly surprising that such if it did exist, such a loophole in the system, Parliament would obviously want to enact legislation very swiftly, which is what it done. But I would urge you not to think that that means there is something deficient in the legislation. I would urge you to say, well, actually, that's not a reason for construing these provisions as my learned friend seeks you to construe them. The legislation in partnership is fairly broad-based. If one compares it with the legislation on employment income nowadays, littered with anti-avoidance provisions left, right and centre, some of which, as we've seen from the Rangers case, proved unnecessary because the basic principles dealt with the perceived problem anyway. So Parliament's understandable need to bring in anti-avoidance provisions were not necessary.
Speaking for myself, Mr. Balder, I'm very happy to accept that the fact that Parliament has legislated to block what might be perceived as a loophole doesn't amount to any kind of implied acceptance that the schemes actually work. One just has to examine them on their own terms and form a view.
I'm grateful.
But however, one also has to bear in mind, doesn't one, that in this case, that there's no suggestion that there was any element of sham in any of these new arrangements. And what was set up was a totally new structure in many ways, because it involved bringing into the picture the corporate partners and the whole introduction of the concept of special capital. Now, quite what that means, I dare say you'll be coming on to, but it's a slightly curious concept. It doesn't seem to be either the same as partnership capital in the true sense, or the same as partnership assets in the true sense. It's something rather different. It's too generous. But having said all that, we do have a situation now where the individual partners choose, yes, to get their remuneration in these two different ways. They go down a route which is specially designed to ensure that the share of profits allocated to the special partner will be treated and taxed as such. And you have happily received tax of 28%, as I understand it, on that footing. So how do you square that with now trying to treat this as being all along part of the profits paid out to the original partners?
Or 15%.
Or 15, well, okay.
Of,
We haven't yet been vouchsafed any explanation as to why 15 was going to be enough for Avon, but
yeah, of course, Mike, absolutely right.
And you have to accept, I think, that the FTT found that there was a commercial reason for setting up the arrangements in this way.
Yes, I completely accept that. That it, the PIP worked by solving the partnership's commercial desire to have the amounts paid on deferred terms,
Yes.
which would lock the partners in, and what made that attractive for the partners to accept is that when they got their awards, they would be tax-free in their hands.
Yeah.
And so with an bearing effective rate of 15%. So yeah, it's not simply good enough for me to say that, well, this is a problem, so you must find in our favour. But the question for the court to decide is, did this arrangement reduce the individual's profit share?
Yeah.
And we say it didn't. And so we get that from starting with the agreements and looking at what it was that the PIP actually involved changes to in the partnership.
Just before we get into the documents, I just wanted to ask you if you wouldn't mind about paragraph 68 of what the Upper Tribunal said. It's on page 246 of 451. Having looked at Rossendale, they say that Ramsey does apply. And then in the last sentence of that paragraph, they say, having decided the Ramsey approach applies, therefore, we now consider the profit sharing arrangements of the partnership, including the PIP, realistically and as a whole. There's nothing wrong with that self-direction, is there? That's what they were supposed to do.
Agreed, yes.
So is your quarrel with their evaluation of the facts rather than any error of law?
It is a quarrel that the Upper Tribunal does not sufficiently analyse the facts of what actually happened. And there are 2 points.
You're borrowing points from Mr. Peacock, really. No sufficient analysis.
An under-analysis of the facts, and in particular, it relates to their sort of critical finding, was that the individual partners didn't have any rights at the time that the profits were divided. Even though they accepted the revenues case that this wasn't simply a free gift made by Special Capital Limited to the individual partners. This was a contractual discretion conferred as part of the arrangement enshrined in the partnership deed, by which Special Capital Limited had to properly exercise its discretion in relation to awards which had been put down in paper and set out what were the conditions for forfeiture.
So is this right? And correct me if I'm wrong. Their legal error was not that they misunderstood the statute, but that they misunderstood the legal effects of the arrangements which governed the partnership. Is that the way you put it? Or do you say they also misunderstood the legislation?
Well, I do say they, in construing this critical concept of a right to share in the profits,
Yes.
they applied those words to the facts in this case by saying, well, the right to share in the profits took place at the moment that the partnership made its formal decision to allocate a share of profits to the corporate partner. And I
So,
say, well,
so you say they misconstrued the definition of profit sharing arrangements.
yes, and applied that by looking at the facts too narrowly, by interpreting the rights to share in the profits as being rights that had to give the partner the right to take out the money at the time that the profits were allocated. And we say no, the partnership had decided what shares the individual should be receiving, albeit on deferred terms, at the time they decided to allocate profits to the corporate partner. So what they were really doing when they were allocating profits to the corporate partner was enabling the corporate partner to fulfill its obligations to reallocate.
You have to be a bit careful here, because the obligation was not an unqualified one, it was a conditional one.
It was.
Well, doesn't that make all the difference?
No, because one simply got to look at who has the rights to share in the profits. That's the ultimate
Yes,
question.
the ultimate right is a conditional one, so until the condition is satisfied, how can it be a right for the purposes of Section 850?
I say that is sufficient a right. Yes, I mean it's a right that's forfeitable, but it is still a right to be considered, which was acknowledged by the letters, is that you have a right to be considered, and that was the intention that the parties had by implementing this. And so I would say it is more realistic to analyse the person with the right to share in the profits as being the individuals who are going to be allocated the profits in the amounts already determined, as opposed to the corporate partner who is simply receiving the profits for the purpose of reallocating the profits.
So you say right includes contingent right.
Yes.
That's what it comes to.
And the Upper Tribunal went a very long way in the Revenue's favour in recognising that all the contractual discretions that were conferred on SCL and Avon had to be exercised properly, and there were very little prospect of those companies exercising their discretion to sort of keep the money themselves. They were fulfilling their role in the scheme. So when one looks at the rights here and say, well, who does have the right to share in the profits? We say it was the individuals, and their profit share didn't go down in any way when the PIP was introduced.
Yeah, the counter argument is, yes, before the PIP it was all straightforward. After the PIP, you have to split the remuneration you draw into two streams. The stream still goes directly to the partner. Again, no problem with that. It's taxed in his marginal rate and so forth. And then there's the 2/3, as it usually turned out to be, which goes through the PIP. But the difference there is that it goes into a structure which has been specially set up, so it doesn't carry any immediate entitlements. And so that therefore the corporate partner is liable to corporation tax on that as its own income, and the entitlement of the member to the second slice of remuneration is conditional not only on satisfying the stated preconditions, but also on the necessary recommendation being made by the, whatever it's called, the supervisory committee, to the special partner. And it's only if such a recommendation is made that any further step can be taken to pass the money on. So why is that not all rightly viewed, even through Ramsay's spectacles, as a purely contingent arrangement, which doesn't give rise to a right unless and until a reallocation is made?
Because one is not concerned in section 850 at trying to find a present entitlement to the money. We're simply looking to see how the partnerships decided to divide the profits between the partners, how to share the profits.
Yes, we are looking at rights, not expectations.
We are looking at rights, but the Upper Tribunal has found there were certain obligations on the corporate partners to give effect to the discretionary awards that have been made, and those rights were enforceable rights on the part of the individuals. The individuals could, like with any beneficiary of a contractual discretion, can bring an action for damages in relation to those.
I don't question that, but that only happens once the right has crystallised, doesn't it? I mean, the argument against you is the rights don't crystallise unless and until the special, the corporate partner makes a reallocation decision.
I would submit that the rights are there even before they've been crystallised.
So what, inchoate rights? How would you put
A right to be considered and on a fair and non-capricious way. And there have been one of the cases in the bundle is a LLP member, Reinhardt and Ombra, as being a LLP member who sues for his discretionary bonus.
yes?
So those rights were conferred, but one has to look at who has the relevant rights within the meaning of section 850 under this scheme. Was it the corporate partners? Were they intended to share in the profits? Was it the individuals? My submission, the purpose of the PIP was to enable the individuals to share in the profits. They were the only people that took the money out of the partnership through a different account. It was simply machinery. But I hope this will become clearer when we look at the LLP agreement. I'd like to show you that perhaps probably tomorrow now.
Yes.
And then once we've looked at the agreement, just to show you the tribunal's account of what actually happened.
I think we should also look at the eligibility conditions.
And the eligibility, yes, exactly, to keep working. So my learned friend says no service was being provided, but the eligibility main condition was to remain a partner. So we will certainly look at the letters and how the letters were communicated and what the effect of that was.
All right, we will do that tomorrow. 10:30 tomorrow.
All right.